Колеги, вітання усім.
Good afternoon, dear colleagues. The next press briefing is a presentation of the results of the monitoring of proceedings of NABU in the courts. And we have our guest, Artem, Romanyukov, National Anti-Corruption Bureau, Vadym Valko, analyst and coordinator of the project, Olena, Kravets, detective of NABU, Vitaliy, Kravets, prosecutor of Specialized Anti-Corruption Prosecutor's Office, and Anton, Marchuk, expert of Center of Political and Law Reforms. I'm Artem Romanyukov. I'm the member of NABU Civil Oversight Council. And now about the topic of the press conference. Half a year ago, we started the project to monitor the proceedings of SAPO and NABU in courts. Why we started it? From the start of the report, from the start of the reform, from the creation of the anti-corruption bodies, there were many speculations about these topics, and it is not weird because when these bodies appeared in Ukrainian society, there is a wish for blood, for some quick decisions, for some quick verdicts, and this issue became widespread. And people ask why the guilty are not in jail. And we were interested why today there are not many verdicts in courts and why there are no real indictments and verdicts. There are many speculations, and people do not understand the difference between the three important bodies, the NABU, that leads a pre-trial investigation, and Special Anti-Corruption Prosecutor's Office that carries out procedural oversight and support the prosecutors in courts, and the courts that should hear the cases and take some decisions. And due to this, there are many opinions who is lagging behind in their work. And in NABU, we raised the question how to bring light to this problem. And we decided that independent monitoring of the process may help. And one of these mechanisms are video recordings. We put them on our site, on the site of NABU. And each person can watch these videos if this is a professional level, and the level of evidence is also professional, and also they can assess the work of the judges. So we carried out this monitoring during half year, and now we want to give you the results of our work, and we do not have enough capacity to control everything. And in NABU and SAPO, we have 155 proceedings in courts at the same time, and we focused on those that fell out of the attention of the media, because we understand that there are many processes that are highlighted by the media, and many journalists and activists, they bring this information to the public, but in the regions there are some court hearings, and not many people attend these hearings. So we covered several regions. We have our observers, our monitors there, who come to court, and they shoot the video, and they also fill the questionnaire, and these questionnaires are unbiased, and the many questions are yes or no questions. So you can see the result of our work, and you may do it by going on our site, the site of NABU. So based on the data we got from the very start, we decided to build some analysis. For example, about the number of court hearings and the main reasons, and taking into account that 1/3 of all the proceedings that are in the court, so 45 proceedings. This data is well presented, and our colleagues are going to present this information to you, and you will see the slides. And I would like to thank our partners who helped to implement the project. This is the platform of civil control of the organization I had, and the Center for Political and Law Reforms, and the Secretariat of the Civil Oversight Council of NABU, and I believe that they carried out quality work, and they filled this resource with good information. So now I give the floor to my colleague. Good afternoon. So I coordinate the process of monitoring, and I monitored the court hearings in Kiev, and I would like to go into more detail about the methodology, and next I will present the figures. So speaking about the regional cases, there are 17 in 6 regions: Vinnytsia, Khmelnytskyi, Kharkiv, Odessa, Cherkasy, and Lutsk regions. And the monitoring is carried out according to the methodology that was developed by the Professor Mykola Ivanovich Gavrinyuk from the Center of Political and Law Reforms. And after all court hearings, we put the video on YouTube channel of Civil Oversight Council, and also the questionnaires are filled in by the monitors, and the questions are built in such a way in order to reject subjective criteria. And the monitoring is carried out according to 3 main principles: the principle of non-involvement in the process, because these are volunteer people who just monitor the court hearing, and the principle of objectivity, and this is reflected in the questionnaire, and the principle of agreement. And before the court hearing and before the monitoring, we met with the SAPO and NABU officials, and we said that we want to start this process, and we do not interfere in the court hearings, and we do not influence the judges, and we have such sections as statistical data, overall data about NABU work, and also the cases in the courts, and the fullness of and openness of information about the cases, and each person, and where and when these court hearings are carried out, and also the timeline of court hearing, and about the duration between 2 court hearings, for example. So this infographics was prepared by Anti-Corruption Bureau, and as of 31st of August, and 73 cases were provided by NABU to court for court hearings, and court hearings were started, and 49 is not started. There was no preparatory hearings, and whether these indictments will be considered by the court. And 33, there were several verdicts, and some people were got guilty verdicts. And 2 people got their verdicts, and this decision, they appealed against these decisions. And out of 45, if we are speaking about 45 proceedings, out of so we attended 123 court hearings, and the majority of them are in Kiev, because SAPO and NABU, they have more cases in Kiev, and here we may cover more court hearings here, taking into account that the Secretariat coordinates this activity, and we may attend more hearings here, speaking about some indicators of fullness and openness of information during this court hearing. So whether each person can get the information about court hearings, and the majority, the information about the majority of hearings, the information is full and accessible, and only in some cases we saw some indicators when, for example, on the site of the court there was no information about the time of the hearing, but only this happened only in 10% of cases, and 14% we observed that there was no information about the actors of the case, whether they whether there was proper indictment, and also also about the information provided each week to NABU, whether the prosecutor's office sent this information, and 18 were not mentioned in this bulletin. For example, if one but these were cases when it was not possible to physically do it on time. Out of 123, 66 were held, and this is 54%. So these 66 didn't happen because, and this is, and we started to identify the reasons starting from April why the court hearing didn't happen. 33%, these were the holidays of judges or their participation in other hearings, and often there were two judges, and one judge was absent. He was in another room, and the cases were taken from consideration because of this. And also we tried to find out information about those hearings, whether judges have time to consider the case during one session, and we may say that the majority of hearings, they last for more than 30 minutes. But also there are cases that have had longer duration, and it is difficult for a judge to, and some cases are held for 2 or 3 years and there are no verdicts. Also, we followed the access to court hearings where the people are allowed to come, and in 99% volunteer monitors, they could come, and in one case there was closed hearing and no one could come. And also we tried to follow whether some representatives of the media present or some interested activists. 58% are there were no one except our monitors, and this is because there are some cases that are not covered by the media. And Rzeszów military hospital case, it was not covered well by the media because it was not, it was rather minor. So about the intervals of the hearings, in the majority of cases, this is 15 days between two hearings, and this is a good indicator, but taking into account that the majority of cases are heard during 30 minutes or less. So 15 days may not allow to hear the case properly. In 15 cases, it was recorded that the case was nominated in 2 months or more. So between the two hearings, so this is the big term. In one case, this is about the grain corporation. A case was brought to the court in April 2018, and there were 5 months between the nomination of the hearing and the hearing itself, and then the judge was recused, and there was an appeal to change the members of the judges board. So you may find all our videos on YouTube channel, and all the information is provided at the website of the Public Oversight Council of NABU, and also we try to follow the cases, and if a person in half or a year may would like to find out information about the case, these 45 cases, so he may find this information. Also, the information about the date and who represents Anti-Corruption Prosecutor's Office and what was the result and what was the result of the consideration of the case, and also about the context and the reasons why and what can be done next. I would like to ask my colleague to tell us about this. Anton Marchuk, please.
Good afternoon to everyone. My name is Anton Marchuk. I'm an expert of the Center for Policy and Legal Reform. In the course of monitoring and issue in our opinion, we made a conclusion that Ukrainian judicial system is important. It is incapable to make judgments in time upon pretrial investigations. 4,600 judges are available in Ukrainian judicial system, and they got 3 million cases per year, so you can count the rate of cases per one judge. And at the first instance, the National Anti-Corruption Bureau, when they consider the cases, they should hear the cases by tribunals of 3 judges with at least 5 years experience, so it is hard to establish to gather such tribunals, and sometimes some judges, they are not in place because of some sick leaves or vacations or other court sittings, so they cannot gather to hear the case. So we think that the highest anti-corruption court should be formed as soon as possible. And we are sure that the key goal for everyone who is engaged in reforming the judiciary is to establish this court out of professional judges and ensure provision of information to the public and to transfer information from a higher qualification commission to the public. We are sure this process should be fast as possible, so that high anti-corruption court commence its operations. So that the goal, which was set in 2014 by our MPs when they adopted the strategy for combating corruption. You can just look at any country where you can see that oversight over corruption cases should be in place. Thank you. I'm giving the floor to my colleagues from NABU and SAPO. My name is Olena Krolovetska. I'm head of the Department of Detectives. The analysis is a vivid example of public interest to the work of anti-corruption NGOs. National Anti-Corruption Bureau of Ukraine they conduct investigations, and the SAPO is in charge of oversight over judicial proceedings in the cases. I will give the floor to the prosecutor of Specialized Anti-Corruption Prosecutor's Office. I would like to respond. I'm an object of this monitoring. So on my part, as to the report, the analytical data is high quality, timely, and I like that the authors of this report they looked for objective reasons of the situation. Of course, some human factor is in place as well, but they are not so intensive. There are some systemic problems which are represented in this report. The monitoring was selective, but this is normal, adequate. Most cases are covered by mass media, and the situation was consideration of the cases are not good. The main problem is collegiality. I do not mean collegiality as it is, because this is the norm, the rule that NABU and SAPO should try cases in some special manner, but the problem is that at first instance court they do not have mechanism how to shape the collegiums. In the courts of appeal, we have the same collegium. At first instance court, the panels of judges, they are shaped on the random principle. In one panel of judges, one judge could be in a group with one judges, and in other panel of judges he can be in the other panel with other judges, and locations may differ. So participation in the sittings is a torture for judges and for the parties of the proceedings. I think that we face the challenge of creating a special court, not our court, but the court to try our kind of cases. It could be fast line court or priority pass court or green light court, where we can consider our cases faster. Because working in the conditions where cases in courts do not move, I should say that we can forget some details of cases if the time of consideration is too long. So I would like to give you the example of one case. I have many cases in my in proceedings, but only two cases were submitted to trials. It should not be like this. Materials, documentation should be submitted to courts. So these protractions, they will pose risks in the next future. We have in SAPO only 3 dozens of staff. So far, we more and more often face the challenge that we should choose to which sitting to go and which sitting we should ask the court to postpone after the high anti-corruption court is launched. 120 cases which we have in courts already, that will be hard. It would be hard for the high anti-corruption court to accept all of them, and it will. And prosecutors also will experience difficulties. The more time we will spend for repeated considerations, the more, the less time we will have left for investigations. So it would be a serious stress test at the commencement of activities of High Anti-Corruption Court and of SAPO. But this will be the chance for some faster movement of court trials. Thank you. Thank you, colleagues. Now the round of questions and answers. Good afternoon, Stanislav Feshchenko, 1+1. So we have addressed technical details, not enough judges, not enough prosecutors, lack of them. And this concerns SAPO. For its time of existence, how many corrupt officials you have in jail, and if you have not, what may prevented you from this? No corrupt persons have been enjoined under judgments. 22 cases have been completed. 2 verdicts were issued. 3 corrupt officials were convicted. 19 guilty verdicts were issued upon arrangements. We did not produce numbers in percentage. We have only absolute figures you can calculate. Why we do not have big fish? We have told, we have voiced this out already today, because the cases are either not heard, they are not tried, or the trial is very slow. So only courts are guilty, or 40 prosecutors of SAPO. As a prosecutor at SAPO, I cannot tell you that only courts are guilty. Prosecutors are guilty too, but we do not have capabilities to submit documents of cases fast to courts. I want to submit the cases fast. And I want any verdicts to be issued. If there are proofs, there are reasons, then just issue non-guilty verdicts. Issue any verdict. It is easier for a prosecutor when the investigation is being carried out. In courts, we are just one of the parties, the same party as the defendants. So I will not hurry, blaming us. I would like to add, prosecutor cannot answer the question why the work performance is substandard. We provided you the figures, 50% of monitored cases out of 120 where the observers were present. We saw that there were no sittings at all, and also protractions take place, because for 2 years when the case is been tried, details of the case, they are just forgotten by the parties. So we presented our research and you can make your own conclusions. I have a question to NABU and to SAPO. 1 year ago, when a part of detectives of NABU lost their secrecy, their identities were made public. Those days, the question was addressed that wiretapping could be conducted. And you so far are not allowed to wiretapping the phone talks. Does this influence the inability to submit cases to court? Yes, according to the Code of Procedure of Ukraine, only 2 bodies can conduct wiretapping of telecommunication systems. They are police and Secret Service. Of course, NABU asks for this because this minimizes the risks of leaks of information. As to correlation with the proofs and evidences, the issue of evidence and what kind of evidence can be used, all this is legislated in the code of procedure of Ukraine. So wiretapping, which we lack, this influence only the risks that the confidentiality of materials may be violated. Some information could leak. And of course, this influences the efficiency of investigations. Andrei Golub, Ukrainian Week. You said that there are 2 specific verdicts made. Are there any non-guilty verdicts? And as concerns the agreements with the investigators, what are they about? And when the case is closed, when no non-guilty verdicts were issued. And talking about verdicts delivered after arrangements with convicts. We had agreements not with organizers of crimes, but with minor figures, with minor involvements in the crimes. So sometimes the cases, trials are protracted. Because parties provide information, and in other cases, guilty verdicts may be awarded. As concerns the cases on which agreements are made, they are made with those perpetrators whose offenses are not so severe, not grave. This is a question of procedure. Sergey Lek, Union. I have a question to NABU and SAPO. For 2 years, we had 2 scandals about the relationship between SAPO and NABU. How did this influence the activities of these 2 bodies, prosecutors and detectives? We are here jointly. You can see both of us here. So the cases are being tried. Olena is the head of detectives department who investigated the case of Amber, and I am a prosecutor in this case, so we continue carrying out our activities despite of some negative communications in mass media, which sometimes happen, unfortunately. I'd like to say, let us not forget about our main task. Our main goal, main objective is investigations and submission of cases to court. So I support the prosecutor, my colleague, his words. We have not stopped our activities and our cooperation, and we carry out investigations. I would like Mr. Artem to assess this opinion. I had a talk with Larissa Golnik, the judge who tried to initiate an anti-corruption case, but she is under pressure and she cannot carry out her functions. Her tries to reveal, to disclose the corrupt behavior of Mayor Mamai fail. As far as I know, the presentation of investigations, when we today present the research into cases which are being tried now, but no Larissa Golnik case is on the trial now. So please, the best way for you will be to submit a request in this case. All cases are general, so your question is narrow. Well, how to evaluate the case, which details I'm unaware about. As concerns Larissa Golnik, I can comment that Roman Maselka, who is present here, he is the head of previous civil oversight council at NABU, and now his certificate has been cancelled because of some Larissa Golnik's actions support. He supported her activities. So, of course, when a person opposes the system, this person will be blamed and fold his reputation or her reputation will be fooled by throwing mud. Well, I would like to thank you because our representatives of SAPO and NABU, as it has already been said today, the activities continue despite of the conflicts at the level of top management. We hope very much that one of the goals of this briefing is to demonstrate you visually that there is cooperation between detectives and the prosecutors. They continue cooperation on constructive basis. This gives us hope that we will have good results from the anti-corruption reform once court proceedings will be improved. You said that you are a prosecutor in an Amber case. So now I know this, and I would like to ask a specifying question. Whether there were public statements, I didn't hear this from Nazar Kholodnitsky, but Rosenblatt and Polyakov told me that SAPO initiated an investigation against NABU detectives. Is this information true? Because Polyakov told that there are proofs, and the case has already been opened. Yes, your information close to truth. The criminal proceedings started for non-compliance of investigative activities and sound recording, because the protocol contains the phrase which is not present in the record, sound record. But there are no judgments, there were no charges served to the detectives. Thank you, colleagues. That's the end.